The Supreme Court heard oral arguments today that could determine whether former President Donald Trump can run for office or even hold office again. This comes after a Colorado Supreme Court decision barring former President Trump from the Republican primary ballot on grounds he engaged in insurrection by trying to overturn the 2020 election, culminating in the January 6th Capitol attack. The Trump legal team argued that he did not participate in the storming of the Capitol and that his actions did not qualify as an attempt to overthrow the government.
For the first time in history, the attack was incited by a sitting president of the United States to disrupt the peaceful transfer of presidential power.
This was a riot. It was not an insurrection. The events were shameful, criminal, violent, all of those things, but it did not qualify as insurrection.
Former Washington Attorney General Rob McKenna joins us, also a King 5 political analyst. Rob, thanks for being with us tonight.
Pleasure. Thanks, Joyce.
It is often, as you know, difficult to get a sense of which way the court is leaning. But today you could hear some of the skepticism from the High Court. What were your takeaways?
I had the same reaction. The court is highly skeptical of this lawsuit from Colorado that would ban Trump from the ballot in Colorado and by extension, many other state ballots as well. I think they're skeptical of it because it really strikes at the heart of democracy, which is to let voters decide who they want among the people who are on the ballot. But also, I think they're worried about this as a precedent in the future, because if Trump were kept off the ballot by litigation now, you can bet that this would be attempted against other candidates in the future as well, not just for president, but for other offices where there's been no conviction on insurrection charges.
You know, many in the country are questioning the legitimacy of the High Court as you speak of democracy. Many Democrats, Republicans, Independents called on Justice Thomas to recuse himself, given that his wife Ginny attended the Stop the Steal rally on Capitol Hill on January 6th. Do you think that he should have recused?
Well, there's certainly a case to be made for that, but he didn't attend the rally. So, I think that it's a big step to ask a justice to step aside. And the fact is, I think you want all 9 justices weighing in on this. I think it's quite possible this decision will not be a 6-3 decision, conservatives versus liberals. I think it could be a 9-0 decision or 8-1 or 7-2, because I think, as we heard in the questions today, even some of the liberal justices appeared somewhat skeptical about the arguments from Colorado that someone who hasn't been convicted of a crime, who didn't participate, in a civil war, as was the case when the 14th Amendment was adopted and Confederate officers were kept off, can be kept off the ballot now. I mean, is this even a decision that states can make without Congress weighing in? These are pretty weighty questions, and I think every justice on this court is very, very cognizant of the reputation of the court and its credibility at the state.
Well, in just a few weeks, the court's going to be weighing in again on the absolute immunity issue, also of huge consequence for the country. What do you expect with that case?
Well, the court could decide to let the case against Trump on criminal charges go to trial. Keep in mind, he's not been charged with insurrection. So even if he were convicted of mishandling classified documents, for example, that wouldn't fall under the definition of insurrection under the 14th Amendment. So they could let him go to trial, let the system work, and then take this question up later. On the other hand, they may not want to leave the question of immunity for some future date, because there's a possibility that Trump will be reelected as president, elected to a second term. And it would be very hard to see a criminal trial go forward if he's in office at the time. So they may want to decide this question now. Having said that, I thought that the 3-judge panel from the D.C. Circuit Court of Appeals, which unanimously held he can be criminally liable for acts that were not official acts of the president, was pretty compelling. It's not the first time. The U.S. Supreme Court ruled that Richard Nixon had to comply with a subpoena related to a criminal investigation. Just because he was president didn't immunize him from that criminal investigation, where the act in question was clearly not an official act, i.e. breaking in at the Watergate. And here, I think it's very compelling that, the arguments are very compelling that Trump was not engaged in an official act as president when he was contesting the election results. Those were the actions of a candidate for president, not of the president.
Rob McKenna, we always appreciate your analysis. Thanks so much for your time tonight.
Complete pleasure. Thanks so much, Joyce.